Okay, how are we all doing today? Hopefully, this will work. I tried to get to the office actually, and there was really bad traffic on 95. So I came home because I was coming from a client. So I came home to do it today for my home office. So today we're going to talk about estate planning with disabled children. So let me introduce myself first, and as people log on, maybe they have some questions. And if you have any questions, please feel free. I believe you can write your questions in as you're joining me, and from there, I will be happy to answer them. All right, so who am I? My name is Yanni Markov. I'm an elder law attorney. I do a lot of estate planning, and I do a lot of Medicaid planning and special needs trust. The purpose of the seminar or the webinar this morning is to focus on where estate planning and special needs trusts really coincide and they come together. Let's start off with what is an estate plan. An estate plan is a document, usually a set of documents actually. It includes the power of attorney, it includes the healthcare surrogate, it includes a living will, a pour over will, and most importantly, the revocable living trust itself. So, what is the revocable living trust? It is simply put a detailed explanation, much like a will is, as to what you would like to have happen to your assets when you pass away. So that's all it is. It acts very much like a will. We use them a lot down here in Florida because of the cost and the time issues associated with probate down here. Okay. Um, what is a special needs trust? Well, a special needs trust is primarily used in two circumstances. The first, which I do a lot of, is when somebody who is receiving Medicaid benefits or Social Security benefits, and I say Social Security, I mean specifically SSI, Supplemental Security Income, not SSDI or Social Security Disability Income. When somebody's receiving those benefits and they have a personal injury settlement and they're going to get a lump sum amount of money as part of the settlement, they have to have a special needs trust put in place. Otherwise, they will lose their benefits. Why is that? Well, SSI and Medicaid are both what we call needs-based, meaning you have to have a need in order to get those benefits. The need is based on two factors. One is income, and the other is assets. So the individual cannot have assets greater than $2,000 per month. If they do, they're not qualified. So what happens is, if you can imagine, even a small personal injury settlement of $4,000 or $5,000 would disqualify the person from a special needs trust, disqualify that person from benefits. That's why we use a special needs trust. The second time primarily that we use special needs trust is in estate planning, and that can either be within the revocable living trust itself, the estate plan itself, where it states, I'm creating a special needs trust, or more, or it can also be done also within estate planning for a grandparent who wants to leave money to a child, to a grandchild who is special needs. And we do that through a special needs trust. Those are really the two circumstances that we use special needs trust. Personal injury settlement or an estate planning either within the revocable living trust itself or through a grandparent who wants to leave some, or an uncle or a family member who wants to leave money to a disabled child. So now the question becomes, what I categorize it as two different circumstances. One is known disabled, and the other is an unknown disabled. And why do I say it that way? Well, a known disabled is somebody who is, for instance, already receiving Medicaid or SSI. And by the way, let me interject for just a second. Difference between SSI and SSDI. So if you are working and you have an injury and you're unable to work for more than 12 months, okay, that becomes, and you apply for disability, and if you worked what is it, 20 of the last 40 quarters or 10 of the last 20 years. If you are vested in the system, your Social Security system, that is SSDI. The average payout in Florida is about 11.49, I believe it is, or no, 12.49 is the average monthly payment. It's a formula based on the number of years you've been working, your average salaries, and a couple other factors, and the percentage of disability. Now, if you have not met that requirement, meaning you're not vested in the Social Security system, you're not entitled to SSDI. What you are entitled to is SSI. SSI is Supplemental Security Income. It maxes out at $753 a month. It is also a formula-based program, and it is needs-based, and that's why these special needs trusts are used, because they're needs-based programs. You cannot have assets more than $2,000. When I say assets, I mean countable assets. So a primary residence, a car, prepaid funeral arrangements, household goods, those are not counted. Everything else is counted. Okay, so what we do, and I do a lot of special needs trusts for PI attorneys, and I really like it. Getting back to estate planning. Let me turn this off. It has the phone. I'll let Tiffany pick it up. In regards to estate planning, when I create an estate plan, a revocable living trust, I always, and I say this always, okay, because the family never really knows what's going to happen in the future. So if they're in the estate plan, if there is a distribution to someone, it doesn't have to be a child, okay? But if there's a distribution to somebody, I always allow the trustee to have the flexibility, where if needed, to distribute it into a special needs trust. Now, you're going to ask, well, why would I do that? Why would I add another 5 pages to a revocable living trust unnecessarily? Well, I don't think it's unnecessary. And the reason is this. Families, God forbid, you can get into a horrendous car accident, and the trust was written 3 years ago. Obviously, you were fine when it was written. But now you're in a horrendous car accident, and I have seen this actually. Not a client of mine, but to a colleague. You're in a horrendous car accident. You're on SSI. You're receiving Medicaid benefits, and an uncle passes away and leaves you a bunch of money. Well, if they haven't done the pre-planning within the estate plan, it's sort of a scramble to get it all done with the distribution and the trustee. It's a lot easier to do it within the estate plan itself. I don't charge the clients extra for this, but what it does do is it allows the trustee to have a little more flexibility in terms of how to distribute for the beneficiaries within the RLT, or revocable living trust itself. Okay. The second aspect is sometimes I get grandparents who want to come in and leave their grandkids money. Well, of course, in the revocable trust itself, and again, and I say always, it's part of my template. I always leave it with a special needs trust flexibility and ability. If the trustee doesn't want to do it, then that's perfectly fine. You can just give the money straight outright. It's not a big deal. But if they do need it, it is there to allow for that flexibility. Because if it did not allow for that flexibility, what would happen is the trustee would distribute it to the person directly, okay? Because they're not allowed to give it to anybody else, either into a sub-trust or into the person directly, okay? So they would give it to the person directly, who is now needs to go find an attorney to do a special needs trust within a 30-day period, okay? And it's not really 30 days. It's within the calendar month, by the end of that calendar month. So if the check comes in on the 25th, they have 4 days to do this in. So therein lies why we do it. therein lies why we do it. The other, let me put this on mute. Okay. The other issue associated with the special needs trust in estate planning is you have a grandparent. They want to leave money, and we create an estate plan. Okay, and that's great and fantastic to do it. Okay, and we put in the flexibility of the special needs trust itself. But let's assume for a second that they know there's a known entity. Remember, I said there's two categories that I categorize it by: known or unknown. So putting it in with the flexibility into a revocable living trust is an unknown. Now let's assume for a second there is a known. So grandparents, I'm sending a voicemail. The grandparents, I don't think Tiffany will pick it up in the other office. The grandparents may want to leave money to a grandchild that they know is disabled and is on Medicaid. And when we say disabled, there's all sorts of disabilities. It doesn't have to be, Wonder is a movie that I actually just saw last week, and it was a fantastic movie. It doesn't have to be something, well, okay, so the kid in Wonder, while he is disabled, um, he's not going to be on SSI or Medicaid. But, sometimes there are disabilities that do require Medicaid services or SSI services. And the grandparents will know that. So that's when we create what's called a third party special needs trust. And it's part of estate planning. Usually they're not part of, they're standalone trusts. They're not usually part of an estate plan itself. It's part of a standalone. And I've done this. So let me give you a recent example of how that would work. I have a mother. Hold on one second. I'm going to put you on pause for 1 second.